So branding is part of your business value, but equally valuable are the things that you create. So you have copyright for your source code. You have patents. Now patents can cover physical objects, they can cover ideas, and they can cover process. To some degree, you have to make a tough decision as to whether or not you want to protect your particular IP with a patent filing, because when you do, that patent becomes public record, and in 17 years, it's going to be public property. If you take things like the original formula for Coca-Cola, if you take the original formula for things like Angostura bitters, those are trade secrets that have existed for hundreds of years and are still secret today. That means that your ability to protect it is much different, and you have to keep a much tighter closed circle around it. So you have that balance of risk between protecting it with a patent and having it become public property in 17 years, or trying to protect it as a trade secret. Copyright is different. It's good for the life of the author, plus 75 years in the US. And as a result, anything that is written down and published becomes copyright with the simple fixation of a copyright notice. That, of course, is probably the least expensive way of protecting something like software. And if you're looking at the gaming industry, for instance, you might find that the life of your software on a particular game is limited to a number of years in any event, and so it's not a big issue for you. Similarly, you need to look at designs and whether they are protected by way of registration or, again, by use of copyright.